present this webinar, which is titled Emerging Insurance Law Responses to the Global Pandemic. As we all know, COVID-19 and its devastation has spawned a tsunami of private insurance claims. These claims run the gamut, from business interruption and directors and officers claims to possible liability claims. Fierce battles are already underway over policy language and coverage. Behind all of this is an overwhelming set of social strains. Shutdowns have dealt a blow to businesses, and we know that sometimes those blows have been fatal. Insurance companies are concerned about the specter of unanticipated claims. Meanwhile, federal assistance to struggling businesses has been woefully inadequate, which has added fire to the urgency of insurance claims and coverage fights. Before we begin today's session, let me just discuss a few logistics. Audience members, remember that this is a webinar and not a Zoom call. So you can hear and see the speakers, but we cannot see or hear you. Instead, if you have questions, please enter them into the Q&A box. We will open up the webinar to answer questions after the panels have ended. And likewise, speakers, if they notice a question and want to address it within the presentation, they are free to. In addition, today's session is being recorded. The recording will be emailed out later to everybody who registered. Speaking of registrants, we are up to 193 participants already and counting today. So I have to say, all of us are thrilled. Welcome here. We have an absolutely stellar lineup of speakers. My job will be to introduce each panel and to act as the timekeeper. Speakers, remember that I do plan to keep the train running on time. So with that, let me begin. Our first panel is called Evolution of Pandemic Insurance Disputes and Suits. And it will be presented by Michael Aylward from the Morris & Mahoney firm here in Boston. Michael, I'm proud to say, is a 1981 graduate of Boston College Law School and the immediate past president of the American College of Coverage Counsel. He is going to bring us up to date with how the pandemic insurance litigation exploded since it first began 4 months ago. Michael, you have 10 minutes.
Let me say I want to thank the law school for allowing us to do this presentation. It is such an important issue of what this litigation is going to mean for the country and for the insurance industry and lawyers generally. This is a good time to be talking. I have never in 40 years seen anything like what's happened over the last 4 months. And it is literally 4 months since the first lawsuit was filed in there we are. A fellow named John Hodling, who made his money in the tobacco litigation and then suing insurers after Hurricane Katrina, filed on behalf of something called the Oceana Grill in New Orleans on March 16th. This was 2 days after the first state closure orders had come down. And there is, in fact, a very close correlation between the number of when new cases are being diagnosed and when new cases are being filed. If you track the two charts, the slope is almost identical. Basically, from a slow start in mid-March, we've been getting 30 to 50 new lawsuits a day. as a week. As of today, there are about 700 lawsuits pending around the country. The hotspots, if you will, are on the coasts. California, as is typical of coverage litigation, leads the way. But Pennsylvania is a strong second, followed by Florida, Ohio, and some other states. And this is really, as with the pandemic itself, a national problem. With the exception of the Rocky Mountain states, Alaska and Hawaii, and West Virginia for some reason, this is pretty much a national problem. What I think is interesting, what I'd like to propose in terms of setting the table for the other presenters, is that we're midway through what I think is going to be 5 phases of litigation. The early suits, the ones that were filed from mid-March on until April, were mainly small businesses, mainly things like the Oceana Grill, although 4 days later, Hodling filed suit on behalf of French Laundry, which is hardly a small business. But the characteristic of most of these lawsuits was that they were relatively small businesses that didn't have connections with large national firms. And as a result, the suits were being filed mainly by small local firms that were not necessarily the kind of people you'd expect to see in complex insurance litigation. Starting in mid-April, there was a shift in the litigation. We're still seeing a lot of restaurants and beauty parlors and bowling alleys, but we started seeing the encroachment of addiction suits, not single policyholder, single insurer suits, but class actions brought up against single insurers on behalf of all insureds in that state or nationally. And the lawyers bringing this were not local law firms. They were people like the Linear Law Firm or Potters and Orsic. These are national firms that for years have sued banks and financial institutions, bringing consumer class actions. By May, there were 3 different petitions filed with the Joint Panel on Multi-District Litigation in an effort to consolidate all the federal litigation involving COVID-19 claims into a single proceeding. The competing proposals were for Philadelphia, Miami, or Chicago. This was a clear effort by certain law firms to really grab hold of this litigation and control the direction it was going. So that was, and this is still pending, by the way. The JPMDL was supposed to meet in Boston on July 29th. At this point, it's scheduled to happen in DC on the 30th because nobody's traveling these days. There are 6 different MDL motions pending before the panel that day. This is the only insurance one. It would be very surprising if the JPMDL granted consolidation. It's never happened in the context of a pure insurance dispute before, and it rarely happens with contract disputes. But, given the growth, the explosive growth of this litigation, there's a lot of pressure on the courts to find ways to be efficient and consolidate these proceedings. So even if it doesn't happen nationally, there are state and individual district procedures where consolidation may occur as the litigation goes forward. That's phase 2. Phase 3 is just starting to happen, and I call these the condo or cartel suits. There was a suit filed a couple of weeks ago in Philadelphia in the Eastern District, where a number of different insureds banded together to sue a number of different insurance companies, not affiliated companies. There was basically 11 different lawsuits joined together as one mega case, presumably to share the cost of the litigation, because none of the individual policyholders were particularly large, but as a result, they could afford McCool Smith. As I mentioned, most of the early cases were brought by small local firms. The problem, and this is hearsay, but what we hear on the carrier side is that the large corporate law firms that typically get involved in these kind of cases don't want to do contingencies. They want retainers, and they don't typically have client relationships with the small gastropub down the street. But McCool Smith is a big player, and we're starting to see these kind of firms coming into the litigation in phase 3. Phase 4 started about 2 weeks ago, and what we're starting to see are the large businesses, not the gastropubs, not the beauty parlors, but people like Disney or hotel chains, or as of today, I'm sorry, in phase 4, you're going to get the bigger corporations bringing suit. And yesterday, the parent company of the Houston Rockets filed suit against FM Global in Rhode Island. I think, and this is just an educated guess, the large businesses that have huge BI losses are concerned about the smaller businesses and these firms that aren't really that knowledgeable about coverage messing up the law. And there are probably 20 or 30 motions to dismiss already pending around the country. So I think the people that have been sitting on the sidelines are now jumping in. I think in the next couple of weeks, we'll see, again, a shift much more towards larger corporations and larger law firms getting involved. Final comment, almost all of the lawsuits, and there are now 700 that are pending, involve commercial property insurance, and probably 97% of them involve business interruption claims. There are few event cancellation suits. So far, there are no CGL suits, no D&O suits, and no E&O claims, although there are a couple allegations that brokers didn't get the right insurance in the BI suits. That will change. If phase 5 comes, it'll be a diversification of the litigation away from just commercial property towards more broad spectrum litigation involving all lines of insurance. So that's where we are at this point. It is an extraordinary amount of litigation for such a short period of time. And what, from a carrier point of view, who are my clients, what's terrifying is that it is a potentially bottomless pool of litigants that may file suits. Thank you, Pat.
Michael, thank you. That was really eye-opening. I have to say, it's just been 5 months since these filings began, and already Michael is seeing phase 4 and anticipating phase 5. So that's really a remarkable development. Our next panel is called Juror Attitudes to Pandemic Disputes. It will be presented by Christopher Martin of the law firm of Martin Desir in Houston. For the last 2 decades, Chris has been at the center of every dispute over major natural catastrophes in the United States and the ensuing insurance litigation. Since pandemic claims began in March, Chris has surveyed thousands of people throughout the United States, polling their attitudes with respect to COVID-19 claims, and he has some interesting insights to share with us with respect to what we may see in the future when and if these insurance cases go to trial. So with that, I give you Christopher Martin, and Chris, you have 15 minutes.
Thank you, Professor, and thank you for the law school for sponsoring us today. It's a great opportunity to talk about something really fascinating, because what prompted this research was lessons learned during jury trials among all the major catastrophes that have hit the United States in the last 2 decades plus. Every hurricane to a major metro area, every wildfire, tornado, in all of those situations, we've learned that in the 18 months right after the catastrophe, local juries view things almost exclusively in favor of the local policyholder and engage in a form of jury nullification, ignoring policy language, ignoring policy limitations, and it becomes virtually impossible to win a major CAT trial involving a major metro area for the first year and a half after it happens. And so we've done a lot of research around those things. And so when COVID hit, it made me wonder whether or not the same type of result might happen because of COVID, except it wouldn't be isolated to a place hit by a hurricane or tornado or wildfire, but instead the entire United States. So my research question was whether or not the scope of COVID-19 losses create a national risk for jury nullification in first-party insurance coverage in bad faith cases. My research discovered that it did. My law firm, along with a PhD jury research firm, Rick Goldberg and Associates in Houston, worked together to create this. We interviewed, did online surveys of more than 10,000 people. We had 127 questions. We had a gender split. We had a racial balance. We had socioeconomic balancing. We also got political and social identifiers in terms of what they like to watch, where they got their news from, how they identified themselves politically. We made sure we were geographically balanced from all 50 states, and then appropriately balanced in terms of gender and socioeconomic and racial status within each of the 50 states, so it matched the most recent census data. Uniquely, we also included all insurance industry employees, and I'll explain why in just a minute. We tested general opinions about the virus as well, including what they think about masks, social distancing, economic damage, and other issues. Because we tested in April and May, we think these results have even gotten stronger across the summer, but we'll figure that out the next time we survey. Our primary goal was to identify what we call filter identifiers, the ability to correlate filter factors and trace ultimate opinions. For example, as I say on the screen, how do working married females in their 30s from the Southwest who watch Fox News, got a stimulus check, and feel very strongly about the freedom not to wear a mask feel about a particular issue, a policy exclusion, virus as a damage, or something like that. And I'll explain how we correlate those issues in a minute. So for example, from our late spring survey, was it necessary to shut down the economy? Our surrogate jurors, which are basically everybody that doesn't work in the insurance industry, you'll notice 69% said yes, it was necessary to do that. The question, I'm disgusted by people who refuse to wear masks when social distancing is not possible, had 70% of those surveys agreed or strongly disagreed with that statement. That's one of those questions I think today would be even higher in most jurisdictions across the country, but we'll figure that out in a couple of months. Our high-level conclusions: most people still like and trust their own personal carrier, but they distrust or even dislike the general insurance industry. That's not a big surprise. That's been true for about 20 years. Masks and social distancing rebels, those who think it's a hoax or thinks it's trampling on their individual freedom, are a small minority, but with very diverse opinions. You can't paint with a broad brush based on our research and say they're all Trump supporters or they all watch Fox News. We found a great deal of diversity across the political and media spectrum on that particular issue. Got to give you a couple of warnings. The first reaction is you got to fight your own personal myopic tendencies. When I discuss this with people, they immediately filter down to their personal situation. They want my results for their next mediation. They want my results for something personal they're doing. And you got to realize our goals are a little bit broader than your next mediation or your next case. You got to avoid overgeneralizations. And our research goal was on how to pick juries with the assumption that not every court's going to grant a summary judgment. If the MDL courts that Mike was just talking about are recognized, I could see one of those courts ruling on a summary judgment issue that disposed of a whole bunch of cases. But because state court cases aren't going to be able to be swept into an MDL, you're going to have courts that just are not going to grant summary judgments, and you're going to have to try these cases. And the historical approach we see in those localized areas where we get natural disasters, some carriers just say, I'll settle everything. My research shows you can't do that. There's too many cases in too many jurisdictions, and there's not enough capital surplus and reinsurance capacity to enable the entire insurance industry just to say, we'll settle all of these. You're going to have to try some because there's not enough money to settle all of them. So if you're going to try them, what are you going to look at? Here's an example. One of our questions was, as a juror, I would vote to pay a COVID-19 insurance claim, even if the policy excluded viruses. My right column there are our surrogate jurors, anybody that doesn't work for the insurance industry. 64% of our survey data nationwide said they would vote to pay a claim even if the policy excluded viruses. The reason I included those in the insurance industry, which is anybody that works for the insurance industry, so it not only includes senior executives, but secretaries and people that work in agency and their lawyers and a whole bunch of different people, we surveyed but separated those out. Because every time I do one of these surveys in a local jurisdiction where natural disasters happen, I get results that look like this. And my clients in the insurance industry say, that's crazy, I don't believe it. So for this survey, I included those in the insurance industry to show them that their views of these exact issues are not normative. They don't track the rest of the country, because you can see 70% of the insurance industry rejected my idea or my question about they'd vote to pay an insurance claim even with an exclusion. Now, the reason I'm talking about juries is because of the three categories of my segregate jury data pool above the highlights. So the 6% that strongly disagreed, the 11% that disagreed, the 19% that are neutral. To me, that 28% are the people I'm looking at if I've got to try one of these cases. And I want to know, what do those 28% of my potential jury pool look like? What are their economic profiles? What are their socioeconomic profiles? What's their gender, racial, age profiles? I want as many data points as I can to try to draw commonality, either state to state or region to region, to try to figure out what is my pool, although it's going to be small, of people that are going to disagree, or at least they still feel neutral on the question of whether or not a virus exclusion can be ignored by a jury panel. Similar question, insurance companies should help businesses damaged by coronavirus, regardless of what the policy says. I had 71% nationwide who said they agreed and strongly agreed with that, which is shocking. We've never seen anything like that in the country. We've seen it in localized areas after natural disasters, but not nationwide. You can see on the left-hand side of the screen how that differs for those employed by the insurance industry. Similarly, as a juror, I'd be willing to rewrite an insurance policy to cover coronavirus costs with my vote at trial. 59% of those we surveyed nationally said they agree or strongly agreed with that. And so with that kind of information, I can drill down and look at individual states. Not surprisingly, the numbers on the coasts are a little bit higher. My numbers in certain parts of middle America are a little bit lower, but because I got data from all 50 states, those numbers are just as strong in Minnesota as they are in Texas, and just as strong in Arizona as they are in Ohio, and everywhere in between. So we've got to be careful on how this plays out as we get cases. One of my questions was, as a juror, I would vote to consider the mere possibility of the coronavirus being present inside the building as a form of property damage to the business. Our panel that's going to talk in a few minutes about property damage is going to focus on this very issue. If the court does not grant a summary judgment and say the virus is not property damage, it's going to go to a jury based on my data. 58% nationally of those surveyed said if the virus is around, that's property damage, and that's significant. Obviously, those in the insurance industry disagree with that, but if I've got to try one of these cases, I'm interested in those percentages above that, the strongly disagrees, the disagrees, the neutral, because that's where I can get a more fairly balanced panel. And I want to find out what are the identifiers, the filter factors that differentiate among those spectrums of diverse opinions. One final question here. It says, as a juror, I'd be angry if I learned an insurance company refused to pay a COVID-19 insurance claim because they said the virus wasn't property damage. 74% nationwide said they would be angry if the insurance industry took that position. Since that is, in fact, the position that the insurance industry has taken over the last 4 months, and we've got a potential of 74% of the jury panel being angry, we've got some issues to work on. And as I said earlier, there's not enough capacity to settle all those cases to avoid angry juries. So what are my preliminary conclusions? It is an unprecedented situation nationally. We've dealt with this locally with a whole bunch of cases after the major hurricanes or after the major tornadoes or wildfires. We could try those or settle those on a local basis. That's going to be virtually impossible on a nationwide level. So we've got to figure out, if cases can't be resolved by summary judgment, how are we going to try them? I think federal congressional attention is needed. I think the national media is misfocused and hasn't figured this out yet. And they're going to need to focus on this, because if you're looking at trying, thousands or tens of thousands of these cases nationwide, you're going to run the risk of some pretty large verdicts, in a lot of cases being bonded up on appeal. That's going to create some eventual financial solvency issues for carriers that we all have to be careful about. And then obviously there's jury selection implications. Next step, I'm going to be reporting this in a publication in the next week. I'm really close to finishing it. I'm just doing some minor tweaks on it, but the publication is basically done. The American College will be sending that out to members. We're going to try to get into some national media, so you'll probably hear about it. Or you can email me and I'll send you a copy of it as soon as it goes public. We're also going to repeat the research in September and October, so we can do subsequent reports and compare how attitudes are changing as we get into the third and fourth quarter of 2020. And then also underway right now, I'm doing a substantially similar survey for liability issues, nursing homes, jails, airlines, cruise ships. And I'm looking at the causation question and the damage question. Are juries more likely to award damage or less likely to award damage? And I'll be reporting on that once we get into the fall. So there's some very exciting issues. This is groundbreaking research. I'm not aware of anybody that's done anything like this anywhere in the country. So it's exciting for me to be able to present to you. I'm excited that you could hear some of our early research projects. We're very excited about it, and I hope you found my comments to be insightful. If you've got questions, I'll be sticking around through the entire presentation. We'll take them at the very end. And you're also welcome to call me or email me anytime, and I'll share with you any thoughts that I have about your particular jurisdiction. But Professor McCoy, thank you so much for the opportunity. And for the rest of the audience, thank you for joining us today. It's been a real privilege. Thank you.
Chris, this was utterly fascinating, and I urge you to, when you're ready, to send us your report, because if you'd like, we'd like to post it on our webinar website.
Thank you.
I think this is incredibly helpful research and certainly eye-opening, so thank you.
Thank you, Professor.
Now that we have the broad picture, let's get into the specifics of these disputes. Our next panel will be on property insurance disputes. As Michael indicated, nearly all of the claims that are in litigation have been brought against property insurers. They mainly involve whether policyholders may obtain business interruption coverage for pandemic-related losses. Here to discuss these issues are two prominent lawyers who often face each other on opposite sides of the aisle. First is Rick Hammond. Rick is a partner in the Chicago office of Hepler Broom and represents insurance companies in complex coverage litigation and bad faith disputes. Rick concentrates on first-party coverage and has been an expert witness, adjunct professor on insurance law at Loyola. Let me tip my hat to you, fellow professor, and former claims manager and state official with the Illinois Department of Insurance. In addition, we are honored to have Hugh Lumpkin, who is a senior partner in the Miami office of Reed Smith and represents policyholders in these cases. Rick and Hugh, you will have 20 minutes, and so let me turn it over to you.
Rick? Okay. Well, number one, thank you for allowing us the opportunity to speak with you. Are you able to hear me okay? Okay, yes. Thanks. You know, number one, I was fascinated by Chris Martin's comments. And the reason primarily for my fascination is because I think he has his finger on the pulse of the issues and actually the issues that I want to touch on. You know, we're dealing with, in my opinion, competing forces of legal and contractual versus public policy. You know, I found it very interesting that Chris, as fascinating as his statistics were, he didn't talk a lot about, you know, direct physical loss and how that's defined, whether the contract is ambiguous or not, whether the law is clear or not, and you know, all due credit, rightfully so from his perspective, because the issue is about the competing forces between the legal and contractual versus, in my opinion, public policy. And Chris spent a lot of time talking about public policy related issues. You know, if I could ask, I've tried to share the screen, if I could ask for the first slide of our presentation. Apparently my screen is not sharing properly. Or there we go. You know, the primary issue that you're going to see in dispute in most cases that we see filed, they're all risk policies with or without a virus exclusion. And they're going to center on direct physical loss of or damage to the property at the described premises. And from a carrier's perspective, the facts in most of these cases are not in dispute. The law is clear in most states as to what constitutes direct physical loss or damage. And the contract, I haven't seen many arguments of ambiguity on these issues. The competing forces, however, I think Chris put his finger aptly on the pulse of what's going on. We see congressional efforts to retroactively undo coverage that's already there or to rewrite policies. We see departments of insurance who are placing stringent measures on the carriers to offer advisory opinions preemptively before they even make a coverage decision on many of these claims, which is very, very troubling because obviously an advisory opinion has far-reaching impacts. We see the regulatory issues from the standpoint of asking carriers preemptively how they're viewing these losses. As Professor McCoy indicated, you know, I'm a former state official with the Illinois Department of Insurance, and I get it. The departments of insurance get huge pressure from consumers, from the legislatures, in terms of protecting the consumer's interests. And I understand the public policy issues also, but the fact of the matter is the policy states what the policy states. The law states what the policy, what the law states, and in most cases, there's little disputes over ambiguity. Now, you know, I've written, by the way, 2 papers on these issues, and I invite everyone to shoot me an email. I'm happy to provide you with these papers. One deals with what I consider to be the court's efforts to redefine direct physical loss, and I point to cyber as an example of that. If you look at some of the cyber cases, you know, back, you know, I used to be a property adjuster. That was my first job out of undergraduate. I was a property adjuster. Back then, you know, if you told someone that data was property, we would laugh at you. We're not laughing any longer because some courts have found that data is considered property, that information can be considered property. So if you look at cyber cases, some of these courts are now taking a fresh look at what is considered to be property damage. And I think, you know, that's where, when we look at Chris's statistics and jury nullification, I think public policy is going to be stretching, pushing the envelope to make it difficult for the insurance industry by looking at what is considered physical. I mean, under normal circumstances, we consider physical loss to be a change in appearance, shape, structural integrity, or physical characteristics of the property. You know, I went in the paper, one of the papers that I wrote, you know, I pointed to United Airlines that, you know, they have a policy that when one of the passengers, or had a policy that one of the passengers or crew members were possibly had been infected by COVID-19, that they took the plane out of service and did a deep clean. You know, I could certainly see where, you know, policyholders could argue that that required a change or could be used as evidence of damage to property. That's pushing the envelope. That's not the historic definition of direct physical loss or property, but under these unprecedented circumstances that we're in today, I think that's the issue that the insurance industry is facing, is not the clarity of the law, not the clarity of the facts or the policy, but it's the public policy issues that are present. I'm going to say one last thing and then turn it over to my co-presenter who represents the policyholder side. You know, we see a lot of bad faith issues, and that's the second paper that I wrote on this issue. It has to do with the issue of bad faith as to COVID-19 and as to good faith claims handling. And, you know, the bad faith, you know, is largely, my observations is based upon how the carriers have investigated the claims and whether they've been too hasty in making a decision. In most states, I don't see that as particularly problematic because in most states, we don't have issues such as bad faith without coverage. But in the few states where we do have that particular tort of bad faith without coverage, that could be an issue where carriers have to be careful in terms of, even though there is no coverage that has been found, that the manner in which the investigation has been undertaken could be looked at with a jaunted eye. Pass it to my co-presenter, Hugh.
Well, thank you very much. And to a degree, I have to agree with Mr. Hammond, but I also agree with Mr. Martin. And a takeaway for someone in my position, and I've been handling first property losses since August 24, 1992, when something called Hurricane Andrew came through my home and the homes of many others. I tend to think, initially, I think of this as a textual issue. That is, does the policy admit of coverage? And however, having listened to Mr. Martin, I can also think that I would be better off convincing a court that I need a jury to determine that for me. And there are, by the way, ways to do this, and I'm going to talk a little bit about that. The first thing I want you to do is understand that if you're in court, a great many judges today are textualists. They're going to look at the language of the policy and determine whether there's a potential for coverage. How you go about doing this is part of the art, because what we do for a living is as much art as science. If you look at the language on the screen in front of you, which is a direct physical loss of or damage to property, a physical loss of property can easily be understood as the inability to use it for its intended purpose. For example, I represented a client after Hurricane Michael who had a beachfront house that after the hurricane got done doing what it was supposed to do, had left the house hanging on a 30-foot cliff. It was declared unsafe to live in. That homeowner firmly believed that that house had suffered a physical loss in the sense that it could no longer be used for its intended purpose. And Mr. Hammond is absolutely right. You have to look at the antecedents. You have to look at the history of the case law that discusses what can constitute a direct physical loss. And remember, the disjunctive means damage has to mean something else than physical loss. So yes, I agree. You look at the cyber cases, and I happen to have the privilege of handling one of the first ones in Florida, at least. And that is whether or not a corruption of data on a computer by a cyber attack or otherwise constitutes direct physical loss of or damage to the computer system in which the data is housed. And if you go back to the early cases, there was considerable debate over whether that was true. That is, whether or not corruption of data is physical loss of or damage to property. And it got to the point, just like we are today, where people were actually measuring the weight of ones and zeros on a hard drive to determine whether corrupted data weighed less than data that was uncorrupted. So you could actually measure the quantum of physical loss that occurred when a computer was attacked. But there are other antecedents as well. For years, we have struggled, since I used to do environmental coverage law, with issues concerning whether E. coli bacteria contamination, radioactive dust contamination, lead, noxious air particles, asbestos, mold, mildew, Legionella, and one of those, or vaporized agricultural chemicals. Do all of these things, even though they only affect property in a transitory way, cause nonetheless a direct physical loss of the property involved? I would submit to you that it does. The insurance industry has swiftly acted to say, we're not going to cover these losses, these business interruption losses. And that's bad because we're dealing with billions of dollars worth of loss every week, literally. And what do you buy an insurance policy for? Well, it's a promise of protection. It's a promise of protection in the event you suffer economic loss due to the inability to use your property for its intended purpose, and it restores to you the income loss which would have otherwise been earned. These are all risk policies. That is, they cover all risks of physical loss or damage. And text matters because there are multiple varieties of the languages Mr. Hammond would admit to. For example, physical loss or damage is sometimes and oftentimes the wording used, but you can also have policies that have what's called a tangible variant. They will say tangible physical loss of or damage to. And I've seen one policy that required a sudden and accidental physical loss of or damage to covered property. So the language in that respect matters. I would point out that in 2006, the insurance industry adopted a virus exclusion. And we can talk a lot about when or when not, when that exclusion rather is effective. But I would argue that a virus exclusion would have been unnecessary in the first instance if the policy did not cover a loss of this nature in the first place. Exclusions from coverage are added by the insurance industry in order to prevent otherwise covered losses from taking place. And the virus exclusion is a good example of that. The insurance industry, by the way, has written early and often about why this pandemic, COVID-19, is not covered. They've used examples like, if you spill coffee on a table, you can clean it up. That does not result in physical loss or damage to the table. And a virus, all you have to do is sanitize the surface. It's a transient thing. My clients do not agree. They are unable to use their restaurants, to rent rooms in their hotels, and do the other things that businesses and people want to be able to do and buy insurance to protect them from, simply because of this pandemic and the governmental orders that have ensued. Many of those governmental orders, including one in Broward County, Florida, just north of me, say in so many words that because this virus can cause physical damage to property, we're going to order your businesses not to operate. And in Louisiana, in New Orleans, a similar order was entered. A similar order was entered in New York City. Thus far, and Rick did not mention it, but there have been two decisions, one on a preliminary injunction in New York that I'm aware of, and another seeking to have the insurance company compelled to pay for these losses, and another in Michigan at the trial court level. Only two decisions. This is a tabula rasa, it's a blank slate on which we're going to be writing the law in each and every state. And because each state's law is different as to how it interprets what may be physical loss or damage, for people like me, figuring out where to sue and in which court and which judges might, as Chris Martin might say, nullify the effect of textual language as part of the analysis that we engage in. Now, having said all of these things, the biggest thing that we fear as lawyers, and this is a practical issue, and as Mr. Aylward alluded to earlier, many of the early cases were filed by people who don't do what I do or Rick does for a living. We are both petrified of learning by reading in the advance sheets that a decision has come down in our home state or in a state where we have a client who's going to be bringing a suit, which is antithetical to the position that we want to take. The fact that larger policyholders are now coming to court and bringing firms that do this for a living to argue these issues is beneficial. I do believe, however, from my perspective, that I have ways of convincing a court that this isn't simply a legal issue. The question of whether or not there's been physical loss of or damage to property can be answered by statistical analysis, creating a jury question as to whether or not the presence of people who are infected in high trafficked areas caused physical loss of or damage to property, because we know, based on the World Health Organization, the CDC, and other sources, that this virus can and will be present on certain types of physical property for extended periods of time. And I would challenge the insurance industry, which has an exclusion for a virus, to then prove that the property was in fact contaminated and therefore there should be no coverage offered. I would like to take that to a jury, in my personal opinion.
If I could just if I could just have a retort with respect to the issue which Hugh, I think, touched on, and that is where I started. We have clear policy language. We have clear, undisputable facts in most of these cases, and the law is clear. That's what we're relying on as the insurance industry and insurance industry representatives for the trier of facts to base decisions on. We can use public policy to argue fairness, but that is not necessarily the issue that is before the trier of fact at the time of trial.
I would say, good luck. And I appreciate the fact that you will be taking a textual approach, and I'm going to be trying to get a court to allow me to convince someone else that there was in fact physical loss or damage. Assuming I'm not in a state where the law, at least like it is in Florida, is clear that the inability to use property for its intended purpose is a direct physical loss. And thank you, Professor McCoy. My son, by the way, went to Boston College Law and graduated recently, and I thank you for the excellent education you received.
Thank you, Professor.
Thank you both so much. And Hugh, please send my regards to your son. We think our students are quite talented here at Boston College, and so it's wonderful to hear that. And Rick, I very much appreciated your comments. If you wouldn't mind, again, we would love to post your two writings on the webinar website. And so I'll follow up with you tomorrow on that. Fantastic, thank you. Our next panel is titled Liability Insurance Disputes. Although the current litigation mainly involves property insurance, there's little doubt that liability claims are also going to arise. Michael mentioned cruise ships and the like. And so we can think of a number of industries that might be the likely target of liability claims. What is not so clear at this point is whether these are going to be suits for bodily injury or property damage, and if so, whether coverage will arise under general liability insurance policies. Here to discuss the liability aspects of the pandemic are Jay Sever of Phelps Dunbar in New Orleans, who represents insurers in a broad spectrum of insurance with bad faith claims, and Chris Mosley of Sherman and Howard in Denver, who represents policyholders in these cases. And so once again, the carriers will face off against the policyholders in this panel. Gentlemen, you will have together 15 minutes. I'll leave it to you.
Thank you very much, Professor McCoy. I am not so sure that this is going to be as much of a face-off as maybe a love fest, because we don't have that much to talk about at this moment in terms of liability claims. I mean, what we are focusing on here in some ways has yet to appear. When I was a young associate, a coverage lawyer, I was with a partner and a vice president at dinner in Philadelphia, and the vice president was saying, "You know what we need from you coverage lawyers?" And I was thinking, accurate coverage opinions, long coverage opinions. I didn't know what the answer was, and the response was, "What we need is prescience. What we need is for you to tell us what the future is going to look like, not just on a claim, but on a series of claims." And prescience is what Chris and I are going to try to give you here, because the stark reality is we're just getting started in the process, and we're not even at phase one when it comes to the question of liability claims. And it's a very fascinating issue for insurers and actuaries who are trying to figure out whether this is a big problem for them and how they ought to prepare for it from a financial perspective. But here we're going to talk about what we know, what we expect, and really try to give you our best guess of how this is going to play out in an insurance liability context. First, let's talk about CGL claims. Hopefully, most of you know what a CGL policy is. It responds to third-party liabilities of any kind that are not excluded for the most part. The key question going into this is COVID-19 related liability really there? Is it really out there based upon where we are? And you'll see on our presentation here, I did the old duty, breach, causation, damages thing, which I hadn't thought about since I think law school. But really, for purposes of thinking about whether there's actual liability, it's very, very appropriate for us to break this down into the elements. As it relates to and I bet Chris and I agree on this, as it relates to COVID-19, is there a duty? Is there a duty to prevent somebody from getting the virus at your business? Is there a duty to clean surfaces, to protect people? And proving causation, proving proximate cause between the breach of that duty, it's going to be a tough one, I think, on some of these cases. And then, of course, you've got damages. You've got to have actual injury. Now, in the CGL world, we talk about property damage, and you can imagine the need to clean up property or the loss of use of property. So maybe that's there. Of course, bodily injury is there with people who are infected. There's also a component that maybe some of you know, which we call coverage B. It's also called personal injury, which includes defamation and other related torts, and maybe that's there. One of the things that, with respect to bodily injury, that we've been seeing and questioning is whether a lot of these claims are going to relate to mental anguish. And we've already had a series of claims related to a cruise ship that involved only mental anguish, where some passengers were claiming that they suffered mental anguish because they were allowed to be on a cruise. And court has just recently, Los Angeles court this week, threw those claims out. But mental anguish alone in some states can be bodily injury. So mental anguish is out there as well. But once you get through the first part of the policy and you decide, well, I've got mental anguish, I've got property damage or bodily injury or personal injury, one of the questions that comes up under GL policies is, do you have an occurrence? And I'll leave that to Chris to talk about whether you think these viruses present occurrences. Chris, I can't hear you. Sorry.
Can you hear me now?
Yes, thank you. You're there.
Very good. Thank you. The wonders of Zoom. First of all, thank you, Jay. Thank you, Professor McCoy. A shout out to Hugh and Rick. I thought that was terrific. And Hugh, as a policyholder lawyer, I just have to tell you, I think you were dead bang right. The question with respect to whether these claims would arise from an occurrence, I think is going to be a really interesting question because I think we are going to see a slew of these claims coming down the pike over the next year or so. I just think that a lot of folks are going to get sick, and the plaintiff's bar is going to just have, it's going to be too tempting not to avoid these claims. And so I think we're going to see a lot of them. And when they come, they're going to be submitted to the carriers, and I think we're going to have a fight on our hands. The issues, I think, that are really going to stand at the center of the occurrence question is whether the, assuming one can establish the causation element that Jay mentioned. The question is going to be whether the acts that the policyholder defendant is alleged to engaged of were intentional conduct, or whether they were negligent conduct, with negligent conduct being covered by the being constituting an occurrence and intentional conduct falling outside of the occurrence definition. One would seem to think that that would be an easy answer, that in fact, if someone, say for example, is sued because their restaurant is alleged not to have properly disinfected the tables or maintain the appropriate amount of social distancing that are required by the various orders, and then someone became sick of that, one would anticipate, well, gee, most restaurants or most stores were doing the best that they could, and that would constitute an accident. Certainly, I think we are not going to see places that are intentionally trying to avoid meeting with the guidelines. However, if we have a slew of claims, I think an argument the insurance industry might take would be akin to what we see in the construction defect land, and that is the mere engagement of the act itself was intentional, and the consequences thereafter don't fall outside of the occurrence situation. And so I think we're going to see that. The other angle I think we're going to see is a real digging by the insurance industry to see if these stores, these businesses, and I'll give you a list of others that we think are going to be at high risk here in a little bit. What steps did they take to keep their premises safe, and to really try to develop the evidence to determine whether there's a viable argument that there was some gross recklessness or even intentional conduct in not complying with the safety guidelines from the CDC or your state governments. And I think that's where we're going to have the fight on the occurrence issue. But once we get past that and we have bodily injury, then I think we have to exclusions.
Yeah, and well, I'll also mention, Chris, that you've got the question of how many occurrences, and that can be a key one, because if you get to that point, when you're dealing with something like a virus, you can get into some fairly esoteric questions about how many occurrences there are. But
which could have a significant impact on the policy limits available.
Absolutely. But as it relates to exclusions, which insurers like to talk about a lot, and I know I talk about a lot in my practice, there are a lot of exclusions that could potentially apply, but very few exclusions that are absolutely likely to address viruses in every jurisdiction. Let me start with probably the most controversial, and that is the pollution exclusion. There is no real decision that would apply across the states that any coverage lawyer could tell you about whether the pollution exclusion is going to apply to a virus. Now, some modern pollution exclusions actually use the word virus, very few, but the real question is whether a virus is a pollutant. And in many states, if not most, that's going to be a very tough call. And in a number of states, that's not even a question, right? But in some states, there is a viable argument that a virus is a pollutant under a standard pollution exclusion. I'm going to skip down to the fungi and bacteria exclusion, which I think is meant for something different than a virus. And so unlikely that's going to apply, but there may be some language out there with these mold, fungi, bacteria exclusions that can be used for some of these injuries. Let's talk about the key one, I think, that insurers will be citing, if they have it, to suggest that liability policies do not respond to anything related to a virus, and that's the communicable disease exclusion. I've given you the policy number there, the form number that's used. That exclusion, I think, effectively takes away any coverage, if it's in the policy, for virus-related liabilities. Impaired property is a very esoteric exclusion that I've litigated a number of times, but it essentially is a exclusion that comes into play when you don't have actual physical injury, but you've got the loss of use of property. And sometimes in a case like this, it will be applicable. Employers' liability exclusions are important because a lot of these claims relate, or a lot of the claims that we think are going to be coming down the pike, but frankly, some of them that have already been made relate to things that have happened at the workplace. And if you're dealing with a claim by an employee, the employer's liability exclusions very likely could apply to preclude coverage. So that's a good snapshot of the exclusions. Let's move on to the question that I think we're really hoping to talk about with you all, and that is, what kinds of claims are we going to see? Chris, you want to kick us off with this?
Sure, I'll do that, and I'll just make one quick point on the pollution exclusion, particularly for those of you who are trying to advocate for coverage. Take a careful look at the language, like you have to do with every exclusion. My reading of a typical standard pollution exclusion indicates that a pollutant is defined as something that is a non-organic matter, a non-living thing. It might be organic, it might be chemical, but it's a non-living thing. These are the types of word splitting that people are going to be getting into in addressing these issues. So we've got here listed for you a number of different types of claims that might be asserted against businesses, but I think I can categorize them into really sort of one major theme with two sub-themes. And the major theme is the negligent failure to keep a premises safe. That's where we think we're going to see a lot of these claims coming down. And the two sub-themes are failure to keep the premises clean. So failure to wipe down the tables, failure to wipe down the registers, things of that nature. And then someone claims, I obtained the virus because of your sloppy cleanup practices. And then the second would be to the failure to enforce protective measures, such as social distancing. Most restaurants these days that are open, or in a lot of states, certainly in my home state of Colorado, limit the number of folks that can be in a restaurant, but it's done by the amount of space between tables. Or wearing masks. Just 2 hours ago, the governor of Colorado ordered a statewide public mask enforcement. And so the types of claims I think we're going to be able to see from those is you failed to enforce that. You allowed people to cruise around with masks not on, or masks just covering their mouth and not the nose. Those are the types of things that will lead to the various types of claims we think we're going to see. What are some of the types of venues that we're going to see? I think really it's safe to say that you're going to see them in any business that hosts member of the public is potentially at risk. What are some examples? Restaurants are an easy one. Shopping malls and stores. How do you like to be a shopping mall owner when how much control do you have over the stores there? Hospitals, nursing facilities, those are easy ones. But here are some to think of as we're coming up into the fall. Colleges. My daughter will be attending Boston College here in the fall, go Eagles. But they're having students into their dormitories. Boarding schools, which are prevalent on the East Coast. I happen to have attended one on the West Coast. Same thing. We're going to have folks attending those schools, and the students are going to be in enclosed spaces. So that theme, I think, is what we're going to see quite a bit in the types of claims and where you're going to, in the types of businesses that are at risk.
I listed summer camps here, and I was mentioning to the panelists yesterday. One of my neighbors had their kids in that camp in the Ozarks that just closed, and they are all diagnosed with COVID. You can imagine that summer camp likely has liability insurance, and that very easily could matriculate to what we're talking about here. We listed cruise ships, but the interesting thing about cruise ships is that they're not running, and I think it's going to be very difficult for cruise ships in the current environment to get back where they were. As I suggested, the one cruise ship claim we know about has been thrown out. There are a few other current claims to know about. One not listed here, but Walmart has a claim in Illinois that was filed by someone who died, by the estate of someone who died of COVID. The allegations are what you would expect, that the employee was told to go to work, that it was necessary, and that the proper precautions to protect that employee were not taken, and that the employee therefore died as a consequence of having to go to work. And again, any number of employees who've had to go to work. Chris was talking about hospitals, but also restaurants and grocery stores. You can imagine that ultimately there may be some decision to file suit against those places, particularly if those places were operating before the mask requirements, for example. You can think of some.
You have 1 more minute.
Sure, good.
Thank you.
But what I want to leave everybody with in terms of the way to think about these claims that are happening is that they really can run the gamut of not just what you're thinking of as failing to clean surfaces, but I put slander matter there. And what I meant was I'm actually working on a case right now out of Florida where a woman has claimed that she lost her ability to do real estate work because her business associates told others that she had COVID. And it's a defamation slander suit. And it's going to be a live case. And so COVID is going to be part of the fabric of liability claims, not just what you're thinking about with people getting infected. And so hopefully we've been able to give you some idea of where we see this going. We didn't get a chance to talk about employment liability policies, but maybe some other day. Chris, you have any last words on that?
Thank you, Professor McCoy.
Thank you.
Chris and Jay, this is really, really fascinating, and I guess we'll wait and see what the future brings. We're living with a lot of uncertainty in all sorts of different ways these ways. And by the way, Chris, I welcome your daughter to Boston College. All I can say based on the memos from the provost is they're bending over backwards to keep people safe. So with that, our next panel is on directors and officers coverage. While the fate of CGL claims is uncertain, what is almost certain is that claims are going to be presented under directors and officers liability policies based upon how businesses and their directors and officers may have mishandled the pandemic crisis. Here to speak with us about D&O losses are Michael Manier and Seth Lambden. Mike is the founding partner of Manier Gala in New York City, where he represents insurers in D&O and professional liability insurance disputes. Mike is the chair of the American College's D&O Practice Committee. Speaking for the policy side is Seth Lambden, who is a partner at Neil Gerber Eisenberg in Chicago. Seth is a past chair of the Insurance Law Committee of the Illinois Defense Trial Association and the incoming chair of the ABA Insurance Coverage Litigation Committee. Seth and Mike, you have 15 minutes. Thank you.
Thank you, Professor. So before we start off with the types of D&O claims we expect to see, actually, could you go to the next slide? Thank you. I'm going to talk a little bit about what the scope of D&O insurance covers. So D&O insurance covers directors and officers when they're sued in their capacities as directors and officers. You can sort of think of it as malpractice insurance for directors and officers. There are typically three types or three coverage agreements within a D&O policy. The first, Side A coverage, covers directors and officers for claims that are non-indemnifiable, either due to the company's insolvency or for statutory or legal reasons. Coverage B covers the company's indemnification obligations to its directors and officers, and then coverage C covers claims against the entities. I'm going to be talking about private company insurance, which covers a much broader array of claims against companies than public company D&O insurance, which is what Mike's going to be talking about. So I'm not aware of any private company director and officer claims that have been brought to date, but I think it would be a mistake to think that they are not coming. There are a number of different claims that you could sort of envision arising out of the coronavirus pandemic. I think, though, where we're going to be seeing a significant amount of activity is in the context of derivative claims against private companies, boards, directors, and officers. In effect, in a derivative claim, the shareholder or shareholders are acting on behalf of the corporation, bringing a claim against directors and officers, claiming that they failed to exercise their authority for the benefit of the company and to protect the shareholders. These suits often arise when there's fraud or mismanagement, self-dealings. In the context of the coronavirus pandemic, areas in which I think we're going to see derivative claims alleging breaches of fiduciary duty with regard to companies' response to the coronavirus, as well as preparation. These suits could be, for example, that boards had failed to heed obvious warnings about the financial impact that a pandemic, and I don't mean just the coronavirus, but that a pandemic could have on the company, perhaps drawing from effects of prior pandemics and leading from those being the failure to prepare. To the extent that the failures to prepare or the mismanagement led to financial losses, then those claims could be brought against the directors and officers, and there could be liability arising from that. In addition to failing to prepare, you might see claims that the board failed to disclose the financial implications of coronavirus that it would have on the supply chain, on the productivity, you name it. There could be a whole bunch of different claims arising out of that. And there is some guidance for these types of claims. Last year, the Delaware Supreme Court issued a decision, Marchand versus Barnhill, and it involved Bluebell Creameries. And this decision sort of set forth what you might see alleged as the standard of conduct required for a director or officer to discharge their duties properly in the context of a contamination event. But in that case, the Bluebell Creamery suffered a listeria outbreak. There was a recall and layoffs resulting in mass economic losses to the shareholders. Shareholders brought a derivative action against the board alleging breach of fiduciary duty. The allegations were that the board knowingly disregarded contamination risks and failed to exercise safety of operations. The court found that nominal FDA compliance was not sufficient, and that in fact the board had a duty to monitor operational viability, to make sure that risks such as listeria were covered, and the board could not simply delegate that they had an obligation to monitor and implement a system to protect against food safety. And I don't think it's much of a stretch to imagine how, at least in certain industries, that standard could be held to boards of directors in connection with pandemic losses. So at a high level, I think that's what we're going to see in private company D&O. I think most notably in the bankruptcy context, D&O policies are often the most important asset, and especially for directors and officers. As I mentioned, Side A coverage applies when the company is insolvent and unable to indemnify the directors or officers. But we often see trustees going after directors and officers' policies, and again, that's usually the most important asset. Now, Mike's going to be talking about some of the claims that we've already seen and are seeing in the public company D&O side. Mike, are you on? Well, I'll cover while he's okay.
I'll thank the professor again and Boston College Law School for the opportunity, and thank you, Seth. On the public D&O coverage side, I think a little history is helpful. It's a relatively new product, and in sort of the wild and crazy days of the 60s and 70s as it was developing, coverage was much narrower. It was a fairly there were just say a lot of coverage disputes because it was a new field, a lot more exclusions. What you've seen since then is that the capacity in that area has grown so much, and the competition, frankly, has grown so much that the coverage on public company D&O policies has gotten broader and broader. And frankly, when you see some of the most common policies for public companies out there now, there may be, you start with the broad, we cover your directors and officers for their acts committed in their insured capacity, and there are 4 exclusions. And so the complexity is not quite there as it is in the private side. Private coverage being much broader, and particularly here, the reason for that is that on the public side, the entities themselves only get coverage for what's called securities claims, which seems like a simple concept, but as we'll see in a second, it doesn't always turn out that way. But this is why what we're talking about for the most part on the public side is 10b-5 actions, 34 Act securities fraud claims, Section 11, 33 Act claims, and derivative claims as well. And some of what Seth was just talking about in that regard apply under these D&O policies. But one thing I would like to call your attention to, and I apologize I don't have a slide on this, is there's a Harvard Law School Forum on Corporate Governance paper that was published just last week on July 8th, where they have looked at all of the disclosures since January 1 this year by all public filing companies. They've gone through every public filing, every Form 10K, every annual and quarter report, every 8K, to follow what companies have been saying about the COVID virus. At this point, with one exception of over 3,600 companies, with one exception, everyone has said something. And when you have that, there's trouble afoot. When you say something, you're going to find people who, when your stock drops because of bad news, are going to find that, well, there's something wrong with what you said, and they will sue. So we will see lots more. Right now, there have been about 16 securities fraud claims that are COVID related. The ones that are probably least surprising, there are a couple of publicly owned cruise lines who are allegedly failed to disclose properly the risks of the COVID and their preparation for it, and then the impact of it in particular when it arrived. A more recent one, which is interesting, I think, is the Geo case, which is a private prison company was sued after an article came out talking about the disaster that was going on within that prison, where they had, despite all their reassuring statements in their public documents, had not properly prepared for this kind of thing. And then, of course, when it did hit, overstated their ability to deal with it. That's sort of the theme you see coming out on the 10b-5 and Section 11 side. As several people have already said, so much of the coverage obviously always comes down to the text, right? What's in there? In the public D&O piece, I think an interesting case to look at is a very, very recent one out of Delaware as well, Delaware Supreme Court. The insured was Verizon, obviously a very sophisticated company. Verizon had done a spinoff, a very large spinoff of a subsidiary. In other words, it was issuing shares in this new company to its shareholders. In connection with that, it issued a number of dividends and so forth. The new spun-off company didn't last very long, went into Chapter 11, and soon the Chapter 11 trustee was suing Verizon for breach of fiduciary duty, for violations of various statutes, including the dividend statute under Delaware corporate law. Surprisingly, when you think about it, there was a dispute about whether this was a securities claim and whether Verizon was covered for it. There was something like $40 million in defense costs at stake that Verizon was seeking coverage for. Supreme Court of Delaware, under what is admittedly a very narrow definition of securities claim in that particular policy, found that no, this is not a securities claim. Even though they were issuing dividends, this all came out of a spinoff. And again, the probably the distinction there and securities claims definitions is there is a broader one that is commonly used that covers common law claims arising out of purchases and sale of securities. And there's a narrower one, which was used in this case, which does not include common law claims and focuses more on rules and regulations regarding securities. Court found that that was not broad enough to provide Verizon coverage for that. That is what I have so far on the public side. Seth?
Okay, well, we have a couple more minutes. I want to talk about a couple of exclusions. As you can tell from what Mike and I are saying, D&O coverage is quite broad, but as Tom Waits famously wrote, you know, the large print giveth and the small print taketh away. And the small print in these policies there's a couple of exclusions that we wanted to address. Now, Chris and Jay had talked about commercial general liability risks. There are a couple of exclusions in D&O policies that are designed to carve out typical CGL risks, most notably for the pandemic being a bodily injury exclusion. We're not going to get into the specifics of the language, but I would note that in both public and private company forms, there are a number of different varieties of these. And on one end of the continuum, you might see bodily injury exclusions that eliminate coverage for bodily injury. And those may just eliminate the types of tort damages that would be covered under a CGL policy. Where there's more controversy are bodily injury claims that eliminate coverage for losses arising out of bodily injury. You know, could that be pandemic-related losses? It could be. That's where we're going to be seeing some of the disputes. I know Mike has some additional exclusions we want to talk about, but just quickly, there's no secret that the D&O market is quite hard right now. As our clients are going through renewals, we've seen some insurers include exclusions that do relate specifically to COVID, or I put up on the screen a communicable disease exclusion, which again is likely designed to eliminate coverage for losses arising out of the pandemic. One thing I would note is that D&O policies typically allow an insured to provide notice of a potential claim to its insurer, and if that notice results in an actual claim in a subsequent policy period, it will be deemed to have been made during the policy period where notice was given. So if you have favorable coverage now and are concerned about an unfavorable renewal, it's a good idea to take a look and see if there are potential claims. Mike?
Seth and Mike, we have 1 minute left. Thank you.
Let me quickly mention two things. Thank you, Professor. One is on the private company coverage, I think an enormous issue is going to be the contractual liability exclusion. You think about the kinds of litigations that are going to come out of the business disruption because of the COVID. People are going to be suing each other. Companies are going to be suing each other for all sorts of things. A lot of them arising out of failed contracts. The contractual liability exclusion, like any of these exclusions, can be written broadly or narrowly. I commend you a recent decision out of the Eastern District of Kentucky, I think again just last week, called Global Holdings versus Navigators, where a variety of tort claims and statutory claims were asserted against a gym company for misstatements made in connection with the memberships, pushing of memberships, promises about what the memberships consisted of. There was a breach of contract claim, sure enough, but there was a breach of fiduciary duty claim, a variety of tort claims in addition to that. The court held in that case that the contractual exclusion in that policy eliminated all coverage under that company's D&O policy. So the language is important, and there are plenty of minds out there. That's all we have, I believe.
All right. All right. Thank you so much. I'm delighted that for our last panel, Marty Pence will be presenting. Marty is a 1982 graduate of Boston College Law School. So we started with Michael from our law school, and we're ending with Marty. Marty heads up Foley Hoag's insurance recovery group here in Boston. He will be talking about the emerging COVID-19 insurance cases that are being filed here in Massachusetts and legislative efforts to mandate coverage. And Marty, if you wouldn't mind, so that we have enough time for Q&A, to try to stick to 8 minutes. I know that's short, but do your best. Thank you.
Good afternoon, everyone. No talking head for me. There's a computer problem which I trust is confined to video and not audio. Professor McCoy, can you hear me? Yes?
Loud and clear.
Okay, good. Oh, very good. So yeah, let's now look in microcosm. This is sort of a nice follow-up to where we started with Mike Aylward. Let's look in microcosm at what is happening in Massachusetts with respect to COVID-19 insurance coverage litigation. I've got a list up here that you can all have a look at. If you want to jot down those civil action numbers, you can follow these cases on PACER. And I have to confess that the compilation of this list was somewhat unscientific, so it's possible that we've missed one or two, but I think this is most of them. It certainly is either all or virtually all of the cases that have been filed in our federal district court. You'll see there's a total of 9 here, reflective of what you've heard already today about how the first place where we're seeing these cases is with respect to business interruption property damage cases. That's where we are here in Massachusetts. 8 of the 9 cases that you see listed here are business interruption cases under property policies. The one outlier is the Corrigan case, which is a case against a tour operator for insurance policies that were sold to the educational tour purchasers. So that one will be a little bit different, although it could be interesting in its own right. So if you look down the list, you'll see that most of the judges of the District of Massachusetts will be in on the fun, at least insofar as these cases don't get shunted off to an MDL. I will mention that one of them, Accents in Sterling, has been stayed by assent of the parties pending the possible consolidation of that case into an MDL proceeding if it happens. I share the skepticism you've heard from others on this call that that will actually occur. The filing dates for these cases range from May 4, the first of them, Legal Seafoods, to just this past Monday, July 13th, the Tony Williams case. The policyholders include restaurants and bar operators, consistent with what you've been hearing, graphic designers, an art gallery, a photography studio, and a retail clothing outlet and a dance school. There's really only one household name, and maybe it's household Massachusetts, and that's Legal Seafoods. So looking for some common threads in what you're seeing in these actions, with one sort of quasi-exception that I'll come back to, the pleadings thus far on file suggest that none of the policies involved included a contamination exclusion, this 2006 ISO exclusion that you've heard from other speakers about. A second common thread is that several of the cases involve policies that took effect after the COVID-19 pandemic was already underway, for example, in March of 2020. Policyholders tend to seize on this to contend that the insurer could have, but did not, insist on a COVID-19 or at least a contamination exclusion, which is an interesting angle, although I'm sure those of us who focus on language will say, well, that doesn't tell you anything. The question is, in the first instance, was there coverage? A third common thread is that there is a great emphasis on lack of insurer investigation. One of the cases, Plaza Deli, which I understand will have Mike Aylward representing the insurer, and perhaps he'll comment on this, and if he's unable to resist, alleges that the denial of coverage was issued on the same day as the request for coverage was received. That would tend to cause an argument of an inadequate investigation. And I will say that I've seen insurers being very, very careful to do an investigation before taking the position, probably having this sort of in mind. That will almost always draw a bad faith claim if one would not otherwise have been made. I think the two of the cases that are the most interesting are the Legal Seafoods case, the earliest, and the most recent, the Tony Williams case. Legal Seafoods is moving quickly. The defendant insurer, Strathmore, has moved to dismiss. That was on June 19, and Legal Seafoods has opposed. The two issues on which Strathmore has moved are the physical loss of or damage to property issue, and under the civil authority coverage, whether a prohibition of access by the government must be complete or whether it's sufficient that access is limited, for example, to essential workers. So those issues might very well be addressed quite soon in that litigation. Tony Williams, what's interesting about that is that according to the allegations in that case, the policy included a limited fungi, bacteria, or virus coverage, which provided limited coverage but didn't apply, and excluded all other losses caused by virus. But Massachusetts changes in an endorsement deleted the term virus wherever used in the endorsement, including presumably in the exclusionary language. So that provides, I think, the policyholder with an excellent argument that, well, then it must be covered, and will make it very difficult for the insurer to say, oh, no, of course it's not covered because there's no physical loss. So that case will be an interesting one to watch. And I think what that reflects, and what I'm seeing in my own practice, is that the most interesting cases are those that include non-standard wording. For example, I have a case in the hospitality industry where the insurer was pretty clearly focusing on the potential for just this kind of a loss. They put coverage in the policy for this kind of a loss. They don't think they did at this point, but they did originally. And they sublimited it. So in a property policy, you may have a grand, huge limit for the basic coverages, but for special extensions of coverage or special coverages, as they're sometimes called, you get a sublimit. So it's a low limit. But I think that there'll be a great argument there that there is in fact coverage. So do not assume you're talking about standard wording. There are lots of variants. The other thing I wanted to mention just very quickly, and then I'll step away, is that there is in fact legislation that could have a significant impact on the insurance industry, to say the least. Proposed legislation. In Massachusetts, we have Senate Bill number 2888, which would purport, at least, to override both the physical loss of or damage to property requirement of the policy and any contamination exclusion. Notably, that if that passes, and if it passes constitutional muster, because it's certain to be challenged, it's with all businesses. I was trying to find the number somewhere around 100 or 150 employees, 150 employees and be a limit. On statutory initiatives at the federal level, there is an effort afoot to potentially have a non-retroactive statutory solution for future pandemics, I gather, that would be modeled on the Terrorism Risk Insurance Act, which would, great oversimplification, make the federal government into a reinsurer for the insurance industry covering these claims and doing the loss adjustment, but that the ultimate backstop would either in whole or in part be the federal government. So there is your microcosm, and sorry again for no talking head, but hopefully you've jotted down some of these case numbers and can follow this very interesting litigation in Massachusetts.
Marty, really appreciate it. As Marty noted, the pandemic dispute with the pending legislation, both in Massachusetts and in a handful of other states, is likely to spark constitutional challenges if the legislation has been passed or is passed. And if somebody could mute. Thank you. And and those challenges will be serious ones. We will also be tracking the legislative front. With that, it looks like we have about 12 minutes for questions. And so, Michael, I'll let you moderate the questions and I'll turn it over to you.
We've had a number of specific questions for panelists, but I'd like to ask a general question of the panel. Picking up on where Marty left off, there are 8 states that are trying to mandate coverage retroactively, which is problematic in a lot of respects. And there is an effort called PREA, the Congress. It may not get past the Senate, but there's support in the House to create a market for insurance. So the question for the panel is this. It's been a soft market for the insurance industry for years. Is this an opportunity insurers will embrace to write policies that fairly priced provide coverage for future pandemics? Or are people going to run away from this and, you know, as policies get renewed, they'll have tougher and tougher exclusions? Somebody be brave.
You're going to see all. I think you're going to see all of the above. You know, right now, carriers, I think, are nervous about the, you know, as I indicated, the competing interests, the competing forces between what's clear, unambiguous, versus the issues of public policy, or using Chris Martin's phrase, jury nullification. Yeah, historically, carriers have written endorsements and coverage where exclusions lie, and we could see that coming forward. But insofar as or absent that, I think we're going to see stricter and stricter exclusions coming forward.
Mike, from the policyholder side, you know, it's been 30 years or so since I represented insurance companies, but my sense of history is a good instructor on this. I think in the short term, we're going to start seeing some of the exclusions Seth mentioned. I know in my practice, I've seen a couple that have been both for D&O policies, professional liability policies. I've even seen a CGL one come out. But I also think that as with all sort of major coverage things that come out, environmental, construction, asbestos, once the insurance industry gets a comfort level for how to manage the risk, then I think that will open up the insurance industry to look at that risk as a new source of business and a new revenue stream, which will be good for the insurance industry. It'll also be good for the general business public out there that consumes those products.
Yeah, Mike, I've already been in the process of drafting new exclusions. You know, to the extent that there was any loose language in some of the manuscript policies, particularly some of the excess policies in these complicated, you know, large organization towers, believe me, they are tightening them and they're doing it now. I'm not going to name names, but there are a lot of drafters out there making sure that there's no way around the next round in terms of virus exclusions.
Last week, I saw a Chubb proposal marketing virus coverage, and it reminded me of the old mold coverage where they granted a named peril coverage, but drastically reduced the available limits. It was very limited coverage. But I thought it was interesting that Chubb jumped out up front and said, we'll cover virus-related risk.
My sense in the D&O world is that market has been hardening the last couple of years, particularly the private books have been just hammered. But I think where they're going to be looking is more in terms of co-insurance, lower limits, bigger retentions and things like that. I doubt that they're going to get very aggressive on new exclusions.
We saw something like this with pollution of the 90s. I mean, for those of us who went through the wars, it was 20 years before the market stabilized. But once it was clear that there wasn't coverage available under the conventional CGL for most pollution liabilities, and actuaries got comfortable writing, understood what the risk was, that they could price it, there became a real market for environmental liability that's thriving now. The problem is that took about 12 years to happen. I don't know that we can live through 12 years of pandemics. I mean, what's startling about the thing that we're in now is how quickly it's happening and how just mushrooms week by week. So, these restaurants and small businesses may not be around to litigate when Congress gets its act together, or that we get through trials and appeals and the litigation runs its course. It'll be interesting. We didn't really have time to talk about employment liability. I will say in my own practice, the liability claims that I'm seeing are EPL claims. And they tend to fall into two categories. One is employees who are forced to go work in meat packing plants or Walmarts, or conditions where they feel it's too dangerous to be there. But ironically, there are also employees suing because they're over 65, or they have risk factors and the employer won't let them work and they want to work. But there are EPL policies, and those are, in my experience at least, are being defended under reservations of rights. Do any of you have a theory or a prediction of what the MDL panel is likely to do at the end of this month? I mean, we have a monster batch of cases pending, short of an MDL, which is problematic in a lot of respects. Are there things courts can do to consolidate this stuff and make it more efficient?
Mike, I thought you did a good job of introducing that issue. It's really not, and I think this policyholders around the country, especially the more sophisticated ones, and our side have both filed briefs to say that you can't have one panel apply 50 different states' laws as to thousands of different policy language. It just doesn't make a lot of sense. But there have been ideas about peeling off separate insurance companies for separate MDLs. Now, I don't think that's a great idea, but some folks have talked about that. I just don't know whether any of this makes sense for an MDL. I don't think it's more efficient, and I don't think it really gets to the point of what an MDL is.
Michael, what I think's been missed in the discussion on the MDLs is the institutional discovery. It's been interesting to me that the policyholders have been advocating the MDL, the carriers have been opposing it, but I think those tables get turned if institutional discovery starts up such that the carrier is answering the same set of business practice discovery across 5 or 6 or 10,000 lawsuits, when there are 1,000 requests for the deposition of the senior executive that runs the claims department. Those issues drive MDL discussion on the carrier side, but it's too early to have those discussions. So I think the issue is premature.
And I'll add 2 quick points on that. One is that, I am a policyholder lawyer, and it wouldn't be beyond me to try to find discovery responses that a particular insurance company has made in different states to see if I can get some inconsistent statements. The other thing, though, that I've been in discussion with a particular insurance company about is, we represent, it's a chain. I won't go into the industry or anything like that, but there are about 1,200 across the country. And the carrier is, the discussion we're having is, from the carrier's perspective, I want an answer, but I don't want it to be public because I don't know if it's a good answer or a bad answer. I want to find it out. So we've actually talked about a concept of a high-low, where there's a payout, and then we go to an arbitration, probably 3 arbitrators. It'll be confidential. If I win, we get more money. If we lose, we don't. But either way, the carrier gets a response, and that may help inform another data point, to use Chris Martin's analogy, to help carriers understand where judges in different places might come out on this stuff and how aggressive to take them. So it's not an MDL, but it's another creative way to try to address the issue.
I think one of the things we don't know, but can't quite predict, is how important discovery is going to be in these cases. I mean, the current strategy, there are literally dozens of motions to dismiss that have already been filed. And, from my client's point of view, these are clean legal issues. We don't need discovery. Thank you very much. Hugh Lumpkin made a very compelling argument for why discovery may be required and why summary judgment isn't going to happen, which puts us in the box that Chris Martin described. And I wonder, to what extent, arguments are already being made that there should be discovery of the drafting history of the virus exclusion, that somehow it's akin to the absolute pollution exclusion, and regulatory estoppel applies. It'll be curious to see what kind of discovery, especially in the bad faith cases, emerges on these things. We had a question about professional liability, which we didn't talk about. And, you know, so much of the media coverage has been on the front lines. I wonder if we foresee any lawsuits being brought against, I mean, nursing homes obviously are going to be an issue, but what about hospitals and clinics?
Michael, to respect our audience's time, we'll make this the last question. Thank you.
All right. Does anyone foresee a likelihood of doctors and clinics being sued? And are there E&O issues that might arise from that?
Yes, I fully expect those to happen. Hospitals, nursing facilities. Yes, the short answer is yes.
I see also a professional liability issue that can arise from an insurance producer standpoint. That I believe that sector is going to be exposed to in the event that the court agrees that there might be coverage on one behalf.
Well, fortunately, our profession is one that is not going to be unemployed for the next couple of years. For better or for worse, this is going to be dominating insurance litigation for quite a while. I want to thank everybody who joined our call today. We put this together on the fly in the last couple of weeks, but I think the audience attendance demonstrates how large the interest is. We're going to be doing a series of these starting up again in September with various law schools around the country. And it won't be a repeat of what you've just heard. We'll be putting out publicity about this in the weeks to come, but by September at least, we anticipate having some real rulings, and I think we'll have a better sense of what the litigation looks like and how the kind of strategies that are evolving and litigating these. So it'll be an interesting drama over the next couple of months. Please dial in again. But meanwhile, thank you very much for participating with us in what I think has been a pretty scary but interesting dialogue. And on behalf of the American College, I want to thank Professor McCoy and all the people at BC for helping us put this together and attracting such an interesting audience. So everybody be safe, be careful, and read your policies.
Thank you very much.
Thank you, everybody. Have a good evening.